First off, is it unusual, from your experience, for monies to be withdrawn from accounts that are thought to have been frozen for investigations to continue into any said matter at all?
It is more than unusual when a freezing order is placed on an account. You would expect that before a freezing order could be defrozen, the affected person would go to court and pray the courts for the account to be defrozen. And it has to be based on cogent and legitimate reasons that courts usually would exercise the discretion to allow an affected person to have access to his account. There are a few instances where the court may give a person access to such accounts by way of, just so the person can go and have his daily bread and routine expenditures met, particularly when the person is not working and that's the only source of his income. But outside of that, it takes a little more to convince a court to have an account defrozen.
Okay.
But in this particular case, I think the lapse of time possibly helped, if assuming they obtain an order from the court, because I think it's been about 3 years or more since this scandal broke out, and so one would have expected that the investigations and possible prosecution would have commenced and possibly ended by now. It's been rather too silent and took a very little being heard of the various entities and offices that are in charge of the investigation and possible prosecution of this issue. So maybe it is this room that the suspect possibly use as an opportunity to have access to his account, if there is any evidence to that.
So how does that now affect the fresh charges or the counts that have been leveled against him by the Office of a Special Prosecutor, for which they are heading to court in a couple of days?
In a lot of ways, because the Office of the Special Prosecutor would have to show that indeed that account existed. Would also have to show that the monies that were alleged to be stashed in those accounts indeed existed. And this, if what we are told is true, that the accounts have been completely cleared of the amounts that stood in to the credit of the accused person before this event happened, then there would have to be more to show that indeed those monies have been unlawfully taken. And if that happens, then it clearly shows that he has tampered with evidence. Okay. And that is another offense completely unrelated to the existing crime that he's being investigated over. Okay. And so there are a lot that would have to come out for us to be able to make concrete pronouncement on some of the events that are happening.
Let's talk now about the counts, or the charges, properly so-called. So they say, for example, he and then his in-law are being charged with 1 count of using public office for profit, for example, and then Ejinime J himself is being charged with 8 counts of using public office for profit and 9 counts of directly and indirectly influencing the procurement processes to obtain an unfair advantage in the award of procurement contracts. How grievous are these?
That is a question that can be very difficult to answer, because the Special Prosecutor would have to prove these in court. And it's clearly from the facts attached to the charge sheet, it's obvious that each of the transactions that the accused person was involved in was used as a separate count of charge, as a separate count for which he's been charged with. And the Special Prosecutor would have to prove each of these specifically in order to be able to secure conviction on any of them. And so I do not think that from the evidence that are out there in the public domain, I do not think that the Special Prosecutor would have much difficulties with those. But you can never tell.
I've heard people raise questions about how some of these monies were, removed from the account, if in fact they were, because we know about the Anti-Money Laundering Act, which speaks about suspicious transactions and stuff like that. People are citing the bank officials, that's in terms of the bank's accounts in which these accounts monies were sitting, for, laxity or complicity in some way or form. I don't know if it's a non-starter at all.
It may not be a non-starter, but it's difficult at this moment to jump into such discussions, particularly when we do not know the basis and the circumstances under which he had access to the accounts, if indeed he had access to those accounts. Because, like I said earlier, if you obtain an order from a court of law to have access to this account, then that issue never even comes up, because an order of a court is good enough for anyone to be able to obtain access to any frozen account. However, if you use any backdoor approach to have access to this account, either because of political connection or any other means that enabled him to be able to access his account, then, of course, the officers of the bank would be naturally be complicit in this whole saga. And clearly, a teller or a manager at a branch may not be able to do this. So it has to come from the very top, and which would be a huge scandal that probably awaits us if the facts emerge eventually.
Thank you. Justice Abdulai is a private legal practitioner helping us with the conversation on this subject. Trust that